Hello and welcome to today's program, Trade Secrets 101, Why This is Urgent Now. This program is being recorded and is intended for information and CLE purposes only. Nothing should be taken as legal advice nor relate to any client matter that may be considered privileged or confidential. Attorneys participating in today's webinar seeking CLE credit must fill out a GT webinar affidavit and include the CLE code that will be announced during today's program. A link to the webinar affidavit can be found in the chat box. Attorneys participating in today's webinar within the conference room must sign in and sign out on the attendance form in the room. If you have a question for today's presenter, please type it into the Q&A box. Introducing our presenters today is Wade Walker, Vice Chair of the GIPA's Collaborative IP Ecosystem. Wade, you're welcome to begin.
Thank you so much for the opportunity to join you today. We're fortunate here at the Greenberg Traurig offices in Atlanta to have a number of guests here, and it's nice to see some friends and familiar faces here. We also have our remote attendees, our virtual audience. We're so thankful for all of you who joined us to discuss this very important topic. A bit about the Georgia IP Alliance. We are about helping improve the lives of citizens in Georgia through intellectual property. We have three pillars primarily that focus on doing that. Awareness and education, which is about raising awareness in IP and educating students at all levels and professionals about IP. We have a collaborative IP ecosystem that brings together the creative minds, the inventors, the artists, the startups, with our protectors, largely our attorneys and insurers, which we'll learn more about today, and our enablers, corporations, venture capitalists, and other funders of IP, to get them all working together better in a way that's efficient and effective to help get ideas from people's heads into the hands of those who need them. And we do it all in a diverse and inclusive way because all members of society are important and their contributions make our products better. So that's what GIPA is about. We're very proud today to be partnering with the US IPA, who's carrying out GIPA's causes on a national level. And as I mentioned, Greenberg Traurig, very fortunate to have Gregory Bombard, Justin Victor on the panel, Mary Guzman, Crown Jewel Insurance. And I would really want to give a special thanks to Mary because she's the one behind starting all this, bringing trade secrets to the community for GIPA and the US IPA when we've not really had a big focus on that prior to now. And it's such an important topic. Just so happy that Mary, you and this great team at Greenberg Traurig and everyone else in the community has joined for this very important discussion. So a bit about Mary. Mary is an insurance industry veteran and pioneer. She has over 30 years brokerage experience advising clients on myriad risks to their businesses, most recently with a focus on all things related to technology, cyber, media, and intellectual property. She's an industry trailblazer and one of the first in the industry to develop and sell cyber insurance in 2000. And she has built Crown Jewel Insurance as the world's first trade secret insurer. Please welcome Mary Guzman.
Thank you so much for that introduction. Before we get started, I just want to say how excited I am to be here and that this is the first ever Trade Secret Committee educational presentation of the GIPA and the US IPA. So there are a lot of trends leaning towards trade secrets and the importance around those assets in today's economy. We're going to talk a little bit about that macroeconomic situation, but I'm super excited to be here and welcome other people who might be interested in sitting on the Trade Secret Committee. So come talk to me if you're interested in doing that. But again, before we get started, I just want the two gentlemen to my left, who are both part of Greenberg Traurig's trade secret and employment labor practice, to just give a little bit of background about themselves, and then I'll jump in.
Hi, my name is Justin Victor. I'm a shareholder at Greenberg Traurig in Atlanta. I'm within the labor employment group, and I focus on litigation throughout the country, often involving trade secrets preliminary injunctions, TROs, everywhere, commonly in Delaware, commonly in Georgia. And that's a majority of my practice.
Hi, everyone. I'm Greg Bombard. I am also a shareholder at Greenberg Traurig, although I am in the Boston office. Traveled down to be here with you today. Very excited to be here. I see that we've got a good, healthy number of people on the Zoom. I'll just say on behalf of everybody in the room, we miss you. We'd love to see you again. Come on out to the next one in person. My practice is entirely in trade secret litigation. I would say 100% of my practice is trade secret litigation. Coming at it from an IP perspective, my cases often involve complicated technology and often trade secret claims in conjunction with patent infringement claims. So that's a little bit about me. I guess we can get into our own war stories as we go on.
Great. With that, we'll get started. And for those of you who are not aware, Greenberg Traurig has developed a really great, first of all, podcast around trade secrets. But second of all, they published a top 10 trade secret case summary for 2022. And I'm sure you've done it for prior years. And I'm going to give myself homework to go read that. But it's a must read and a must listen to. So I highly recommend. With that, I'm going to jump in. We talked a little bit, or I said that I was going to share with you some of the macro trends. This is the agenda that we're going to go over today. Just so you know, when we get to the trade secret law and legal theories part of this, we're going to switch presentations and the logos are going to look different, and it's going to be the Greenberg Traurig show at that point. And then it's going to come back to me for kind of risk management best practices from a business perspective, not a legal perspective, and what the insurance market looks like today and where we think that's going. But just to start out the discussion, there really is a shifting landscape in intellectual property, and I think that's for a lot of reasons. Trade secrets have become an extremely valuable asset for most organizations. If you consider that according to Ocean Tomo, up to 90% of the value, 90% of the value of the S&P 500 is now in intangible assets. That's a massive, staggering number when you consider it. Many of those assets are personally identifiable information and other types of data or digital assets that wouldn't rise to the level of trade secrets, and certainly not everything that's a digital asset is a trade secret, but by our estimation, there are trillions of dollars of trade secrets within those numbers that currently are not insured at all. The insurance market has really struggled with the way to develop an insurance product that covers the value of these extremely valuable assets. And that's part of why I formed my own company 3 years ago, to specifically try to tackle that and create a new industry vertical in the insurance industry. We'll talk a little bit more about that later. But as we can see from this slide, I think there are a lot of trends that are driving this change in favor of trade secrets, I'll say. And that is that, frankly, today's assets are different than the assets were even 3 years ago, with the advent of machine learning and artificial intelligence and, chatbots and financial algorithms and software code and all the things that drive today's economy. Sometimes it doesn't make sense to try to patent those because the longevity of the value of those assets doesn't lend itself to patent protection. Getting patents approved for those types of assets can be challenging, and there are a lot of other reasons why organizations are sort of leaning in favor of potentially trade secrets as the mechanism to protect their intellectual property or innovation assets, as opposed to, culturally speaking anyway, what used to be kind of a race to the patent office. He or she who patents the more, wins at the end of the day. Patents are still extremely valuable. I'm not suggesting in any way that they aren't. It's just that trade secret assets can be just as valuable, and sometimes they're sort of the ignored fourth category of intellectual property asset that doesn't get nearly as much attention. Not to mention the fact that trade secrets, by their very nature, derive a lot of their value from their secrecy. And once you file for patent protection and that patent patented technology becomes public information, there's no longer any trade secret value to that asset. It invites other copycats to come in and, sort of do something that's very similar to what was filed in your patent application. And I think a lot of organizations are starting to realize that if there is robust protection that they can rely upon for trade secrets, sometimes secrecy is better. And the Defend Trade Secrets Act, I think, was an impetus for that, which it passed in 2016. It's the federal statute that covers trade secrets. We're not going to go into that in huge detail today, but there's been a huge uptick in trade secret claims following the passage of the DTSA. And certainly people are paying more attention to these valuable assets. I think, and there's definitely smatterings of Mary Guzman's opinion in here today. So I'm going to go ahead and take either credit or criticism for that. But I think that there is going to be a very significant boardroom and corporate exposure for misappropriation of trade secrets coming down the pike. There are a lot of reasons for that. I think organizations today, generally speaking, have not done a great job of identifying upfront what their trade secrets are. Most organizations don't really have a great sense of how valuable they are. Senior executives, especially on the financial side within organizations as opposed to the legal side, maybe haven't taken the time to try to put a fair market value on trade secret assets. Maybe they don't know that they can be valued up front. They're not carried on the balance sheet of an organization unless they are bought, during an acquisition. And so if you can't carry them on the balance sheet and you can't insure them and you can't get loans against them, and then kind of what's the point of valuing them? But that whole paradigm is shifting. You can value them, you can insure them, you can potentially get loans against them. And so I really believe that organizations are going to have to pay a lot more attention to how they're mitigating and managing this exposure. My background, as you might have heard from the beginning, has been in the cyber market. I was there at the very beginning. It was painful to develop cyber and get people to pay attention to that before the claims started coming in. But if you follow the trends, now you see tag along or securities claims following cyber breaches very often. They don't often prevail, and for various reasons. But I think that trade secret assets are even more vulnerable to D&O securities class actions and derivative claims following a breach than personally identifiable information is. The reason for that is that the theft of one single really valuable trade secret can tank the value of a company overnight. And if the board of directors has not paid attention to what that asset is, how much it's worth, where it is, who has access to it, and what they're going to do if it goes missing, if they don't have a recovery plan, I find it hard to believe that they're going to be able to make the argument that they were living up to their fiduciary obligations around risks that face the organization. Again, if the trade secrets are really important. So I think that's coming down the road, and part of our job is to look down the road and help people sort of prepare for changes in litigation and what we think the environment is going to look like.
I'll just chime in and say that there have been those claims filed, actually. And when you see some of these really big verdicts coming out for trade secret misappropriation, and it's on both those shareholder derivative claims are on both sides, because the question from the plaintiff side is whether the board did enough to implement policies to ensure the trade secrets are not being misappropriated. But on the defense side, if you're rung up for a huge verdict for misappropriating the trade secrets of a competitor, you've likely made a bunch of public disclosures about your own IP and the respect for third-party intellectual property rights, which plaintiff's bar will throw back in your face.
And also, just to chime in on that, in Delaware, where a lot of companies are incorporated, there's something called the 220 request that plaintiffs' lawyers have been using a lot of times for potential care mark or breach of fiduciary duty claims, where they can actually probe into, after a trademark verdict, okay, what were the procedures that you put in place to identify your trade secret? What were the procedures that you put in place to protect these trade secrets? So the landscape and the playing field is certainly there for the plaintiff's bar to take the next step with these large, very large verdicts we're seeing, and to extrapolate that to securities or corporate governance actions.
Great points. Yeah, so the next slide is really just to emphasize even further that, we're not in Kansas anymore. Please don't be offended if you live in Kansas, but meaning that these are really big matters, as we just discussed. Several of the claims in the last 3 years have reached sort of that 2 billion with a B, $2 billion number. And I think a lot of people who don't live in the trade secret world and don't follow the trades all the time really don't have any idea how often these claims are coming down and how big the numbers are. So this is statistically just meant to give you some backdrop information. I think it's really important to know that the average trade secret misappropriation claim takes 2.7 years to settle and costs $4.1 million. In defense expenses and forensics and other. So these are very expensive cases to litigate. The higher the value of the trade secret or trade secrets that are at stake, the larger those numbers get. So that 4.1 million goes to 7 point something million if the trade secret is worth more than $25 million. So these are very expensive. And from what I understand, and I'm not a lawyer. I don't know if I said that at the beginning, but just to make that very clear, I'm a risk management professional. But when I go to conferences, IP conferences and trade secret conferences and talk to people that are lawyers in this space, it's always interesting to me to hear them talk about the expenses around discovery and the associated time with that following some of these claims, particularly if the client hadn't really done a great job of identifying the trade secrets up front, because then that backwards discovery, trying to look backwards and see what the trade secrets were and define those with specificity and look back at how well they were protected, is a very time consuming and very expensive activity. One of the other things that I wanted to mention about this slide, and I think it's interesting given what we're talking about today, is that the good news is that you could still protect your trade secrets even in absence of employment agreements or non-compete agreements, which we're going to talk about in a second. But California, as the state that everybody generally is aware of that has not had employment agreement or non-compete agreements, they're not allowable in California. And so if you compare the numbers of the successful trade secret misappropriation claims in California for cases that go to trial, in California, they're successful 44% of the time. This is according to the Stout report in 2020, which is a great place to get information. The rest of the country, where trade secret misappropriation claims are very active, and generally speaking, where non-competes are legal, the claims are successful 68% of the time. So they do make a difference. Non-compete agreements, there are certainly other contributing factors about the culture of the tech world in California, and that's kind of, it's kind of perceived as acceptable anyway for somebody to go from one company to another and take what they learned in their coding from the previous employer. So some of it is cultural, but clearly the numbers, the gap in the organizations or the states where trade secret misappropriation claims are smaller is where non-competes are not legal. I don't know if you guys have any comments that you wanted to add to that. Nothing? Okay. The next slide is just talking about what the proposed FTC ban does. And generally speaking, it's really broad. We're not going to talk today about whether or not people perceive that the FTC has the ability to even enforce this rule, or whether or not we think it's going to pass. That's kind of beyond the scope of this discussion. But it's clear that we are in a different place now. Whether this federal rule passes or not, New York State just became the 5th state where I'm not sure. I know it passed both sides of the House or of Congress in New York, and
hasn't signed it yet, but we'll see what happens.
We'll see if there's a veto or not. But clearly that is the trend in the United States, is towards the banning of non-competes. And so what we're going to examine today is what you can do to mitigate misappropriation risk and enforce your rights following a misappropriation event if non-competes are banned. And so I'm going to turn it over to my friends from Greenberg for a moment, and then we're going to come back and talk a little bit more about risk management strategies and the insurance market.
Please pardon the interruption. Attorneys participating in today's webinar seeking CLE credits must fill out the webinar affidavit and include today's first course code, which is 23129. Again, the first course code is 23129. A link to the webinar affidavit can be found in the chat box. Thank you.
So thank you so much, Mary. That was incredibly helpful. We're going to move on to a review of trade secret law, starting off. What the heck is a trade secret? The interplay between trade secrets and patents. We're going to discuss misappropriation and what that means. And what if you get stuck in one of these lawsuits and you're facing a claim of trade secret misappropriation? What are the potential damages that you could face as a company if a court or a jury determines that you're liable? And after that, we will discuss protecting your trade secrets and then hopefully address any questions. And I'll just say throughout this presentation, for those in the room, feel free to interrupt or put your hand up if you have any questions about anything. I want to be engaging as possible, and nobody wants to hear me talk for 20 minutes straight. Trust me.
That's me? Okay. All right, so the first question is, since we have been talking about trade secrets for like a half hour already, what is a trade secret? And since I assume everybody attending this is in some form or another an intellectual property attorney or an intellectual property professional, you probably have good familiarity with a patent. And I like to say that patents are very bottom up, right? You start with an invention, you go to the government, you reveal your invention to the government, you have an exchange with the patent office, and eventually the government tells you what the scope of your monopoly is. So the invention is defined in advance. Trade secrets, in some ways, are top down. They're just the opposite. And you can see on this slide, the definition of a trade secret in the Defend Trade Secrets Act, and this is similar under all state law, is it can be any form of information. Any form of information, as long as the information is not generally known or readily ascertainable by proper means, and the owner of the information has taken reasonable measures to keep the information secret, and that the information, by being secret, derives economic value. So companies have all kinds of secret information, all kinds of proprietary confidential information. The basic separator between things that are merely confidential business information and what could be defined as a trade secret, a good rule of thumb, is it something, the question is would it be embarrassing if it got out? If it's just going to be embarrassing, if the secret information is that your CEO had an affair, then that's not going to qualify for trade secret protection. If the information has economic value, if it's a formula, if it's a process, customer list, things like that, those have economic value by being secret and not shared with competitors.
So some examples of trade secrets: manufacturing techniques or refinements, protocols, experimental data, patent applications, business plans, and negative know-how and whatnot. And I want to focus on something that I see a lot, which is business plans. You have a lot of people within your company at different levels of the organization, especially at the senior level, who understand, especially in a technology company, what are we working on developing? What are the threats that we see to our product? And if an individual who has access to, I'm talking, senior business meetings, meetings on strategy, meetings on where you're deploying your economic resources, is able to take the content of not only where your company is now, but where the plan is to go in the future. That information, which I would argue is trade secret information if it's properly protected, could be extremely damaging if it was in the hands of a direct competitor. And this is something that we see as lawyers all the time, because individuals who are not attorneys are often in these senior level positions, and they get hired by a competitive company, and they just think it's okay to take their last slide deck or their white paper on plans for next year and discuss it with their new competitor or the CFO of their new competitor. Well, this is what my prior company was trying to do. So sometimes trade secret misappropriation is a malicious act, and it's, surreptitious, and there's kind of all these sexy factors to it. But sometimes it's just people who are not sophisticated in the law thinking that it's okay to take kind of their business plans from their prior employer and use it with a competitor.
I'll comment just briefly on that to say that for all the in-house people in the room or on the Zoom, you get a lot of attention paid on this subject matter, including today. We're talking about how to protect a company's trade secrets primarily. So we're thinking in the shoes of a would-be plaintiff, how to prevent your information from going out the door. But do not forget, don't sleep on the possibility that your company is accidentally being tainted by a third party's intellectual property by bringing people into the company. And what you just said, it's like the most common fact pattern is that somebody moves from company A to company B, and you can tell them every which way not to bring anything with them, but it's only in the maybe 10th time that you have that conversation that it comes out, oh, you mean the slide deck that I presented to the board last year? That was like my proudest moment. Of course I can take that with me. So just, it's something to be aware of, especially if you're tasked with this type of protection of trade secrets within a company. You should also be thinking about potential liabilities of bringing in other people's trade secrets and avoiding that.
And I just wanted one tag on that. And the critical point, if you're a company hiring somebody, is the onboarding process, and ask those critical questions. You didn't bring anything over here that was confidential from your prior employer, and you didn't intend on using that along the lines with your employment. And oftentimes we advise clients, to have, something signed that you didn't do something along those lines to provide some kind of protection. But this is such a common fact pattern. And with the trends with non-competes kind of moving against their enforceability, both at the federal and the state level, these are the types of questions companies need to be asking. How are we protecting and how are we avoiding misappropriation?
This slide, again, speaking to a room full of IP practitioners, this slide sort of compares what trade secret litigation is like in the two, in a patent case versus a trade secret case. And I could add a bunch to this slide. For example, 101. Think of all of the most odious patents you can imagine. Business method patents, naturally occurring genetic sequences, software, right? This type of things where if you're a patent litigator, when you see that case come in, you think, ooh, this is going to be an interesting one. We're going to blow up this patent. All of those things are awesome trade secrets, right? You can discover a naturally occurring genetic sequence, and as long as you keep it confidential and you have a way of using that getting economic value from that, protecting it as a trade secret is perfectly fine. Same thing with your software. And we're seeing a lot of software cases now, sort of as an echo of Alice, where now you have to protect it as confidential information. Your source code has to be protected as confidential information, rather than going out and trying to patent everything.
Just to add to that, the other thing that I think people don't really factor into whether or not to patent versus leave something as a trade secret, if it could go either way. One of the critical things about a trade secret is it has to be very difficult to reverse engineer. And so that wasn't one of the things that was previously listed, but that's a really important thing to think about, that as soon as it's released, if somebody can physically take something apart and make it themselves, it's not a trade secret. It needs to be patented. So that's one thing to keep in mind. But if you are going to patent something, it's expensive. I mean, you guys could speak to this better than I could, but just getting patent protection in the in U.S. jurisdiction can cost $50,000. If you want to get that protection all over the globe, you sort of shopping around to figure out, do I need to protect this in Germany or the EU, or where do I need to protect my patents? It can be very expensive. Is it worth it? That's something that companies really need to be asking themselves.
Great point. I think there's a rule of thumb that you shouldn't ever have a slide that looks like this. Roughly.
So I gave it to you.
Thank you. Thank you. Oh, question in the back.
A quick question on this point. Is trade secret national or international? Meaning, do I have any, so patent, I have to apply in all those countries to get protection. Copyright, it's different. For trade secret, do I have any protection outside the US? Pick your favorite country. Or yes, please.
So very, very good question. Historically, trade secrets were only protected at the state level, right? So you only had state level remedies. With the passage of the 2016 Defend Trade Secrets Act, you now have a national uniform standard. And there is some developing and good case law that act applies to acts of misappropriation that occur outside the United States. And so there have been cases where a foreign company has a trade secret and a foreign company misappropriates the trade secret, but there's enough of a jurisdictional hook for that technology in the United States because of anticipated sales in the United States to be able to apply the Defend Trade Secrets Act to that act of misappropriation that it was entirely outside of the United States. Once you get out of the United States, many countries have a version of a protection for trade secret technology. And that is evolving. You know, the new why am I blanking? The new NAFTA has a provision requiring updates to Mexican and Canadian IP law to conform more closely to our Defend Trade Secrets Act. The European Union is starting to strengthen protections for secret information. And so you're seeing, maybe as an echo of our update in the United States update in 2016, and an increasing focus on this issue, other countries also strengthening protections for confidential IP.
And the one thing I would add to that, from an insurance perspective, we very intentionally focused on the Defend Trade Secrets Act, the federal statute, and where we are comfortable taking on exposure for trade secret misappropriation. As long as the company is domiciled in the US, they can have trade secrets anywhere, and the misappropriation can happen anywhere. And really the key for us is that there has to be that jurisdictional hook for us to be able to use, presumably, the Defend Trade Secrets Act. There are also a couple of things just really quickly that are awesome about the DTSA that you wouldn't find around patent protection. One is that there's the ability to get an ex parte seizure order if you can show evidence that not only that the misappropriation occurred, but that the disclosure of that information would be, irreparably harmful to your organization. And number two is that if you can show that the misappropriating party intentionally or egregiously, or however it's worded, misappropriated your trade secret, meaning a company hired a bunch of your former engineers and either turned a blind eye or intentionally didn't make sure that they didn't bring information with them, for example, you are entitled to exemplary damages. And so, the damages component of this can be huge. And it's meant to be punitive. That's the whole purpose of it. So.
Another question. Fantastic. I love this.
Okay, there we go. If there's time, can you expand a little bit more on the negative know-how? I've heard about that more in the last couple of years, and it just seems like one of the more abstract forms of information. And how much is that coming up, and how is that being defined?
A great question. And if we go back, we had that on a slide here at some point. Negative know-how. So the concept here is that you start developing, let's say it's a drug, and your initial research and development phase is you're just doing like either machine-based or whatever. You have someone in a lab just running a bunch of sequences and trying a whole bunch of different things. And that takes a year. And eventually you've determined there are 3 or 4 different candidates that are the best. Here are the 4 candidates that are the best. The negative information is the million candidates that you've now determined are you're no longer going to pursue. So before the Defend Trade Secrets Act, some state law required that you actually use the information. In other words, in some states, there was no such thing as a negative trade secret. You had to actually be out there using the information, selling it. Now it's much more clear under the Defend Trade Secrets Act and in some states as well, that the idea, if you've passed over certain things, it's all the trial and error, right? So all the errors that you've done. If your competitor gets you all of that information, they can avoid an entire year's worth of expense and delay and just jump straight to the thing that works. So that's the idea of negative, protecting negative know-how, things that we know these things don't work. And so don't bother spending a year chasing this rabbit, to use an imperfect analogy. That's what a negative trade secret is.
I assume people are trying to argue that the negative know-how sort of becomes, this is not a well-articulated legal argument, but becomes kind of part of your general scientific knowledge. So if you go to a company, competitor, legitimately, and a particular experiment isn't going to work, are you supposed to just allow the company to move forward and just keep your mouth shut? And I mean, it just seems like you become knowledgeable as a scientist, like in that particular example, of what works and what doesn't work. And how is that being litigated?
That is a fantastic question, and one that is somewhat unsettled. There is a sort of, I don't know if you are if you're asking for a friend, we can talk later. There's this sort of countervailing, we have all these very strong protections for intellectual property, including the Defend Trade Secrets Act. But so many of these cases come out of the labor and employment realm, where you have a scientist moving from company A to company B. And so in every state, some more so than others, but in every state, there's this doctrine that you do not own an employee's general skill or knowledge. And so if you're going to try to say, we brought this guy in and we taught him how to hold a pipette a certain way, and he now has this ability, it's fantastic ability to just fill all those vials. You don't own that, right? Even if it is a proprietary way of holding the pipette, that guy can go and work for a competitor and use that same technique without breaching any kind of confidentiality obligation. The factors that there's actually a very, very excellent Boston Bar Journal article on this very subject, which is not in the handouts, but you can find on my bio. That there are a couple of factors that weigh on this. One is, did the person take information with them? It's hard to argue that you are just employing your general skill or knowledge if you walked out the door with a briefcase full of confidential documents. Like, why did you need those? That's one issue. Another is sort of how generally well known is this concept in the industry. Did the person come to the job with, in the example of a scientist, you often see people, they're in biotechs, there's sort of this hierarchy. There's the PhDs, there's the people who just have master's degrees, there's the people who have undergrad degrees. And so the people who come in with an undergrad degree and work for a company and then walk out with a bunch of information, that's much more likely to be seen as a trade secret versus somebody who comes in and is the chief science officer and is developing the sequence. There, the argument for that chief science officer, when he goes to the competitor, is, well, I developed a thing for you, and you hired me because I was a talented scientist. I can go to a competitor and develop the same thing for that competitor because I am a talented scientist and you don't own that talent. But that's a very great question and very fact intensive.
And just to kind of move things along here, I want to go back and talk about damages for a second. If you are found liable for misappropriating trade secrets, the damages can be astronomical, because under the Defend Trade Secrets Act, it can be the actual loss caused by the misappropriation, if the plaintiff can show that. It can be unjust enrichment damages, which it's not addressed in computing damages for actual loss. And then, the third, which I think is really can be concerning, and you see a lot of cases potentially settle because of this potential hit they could take, it's a reasonable royalty for the misappropriator's unauthorized disclosure of the trade secret. So, that multiplier in the form of a royalty as a result of the disclosure or misappropriation is something that you've seen, in my opinion, really drive up settlements, the number, the damages that you see in verdicts as well.
And this disgorgement theory, right? The idea that you can disgorge the defendant's gain, again, very unlike patent litigation. In patent litigation, where you have a reasonable royalty and you have apportionment and you have an ability to sort of whittle this, the value of the patented technology down, you hope, to very little if you're the defendant. If you're the defendant in a trade secret case, one very common measure of damages is disgorging all the profit that you've made by using the trade secret. And the way procedurally this plays out is once the plaintiff has asserted that, the burden can shift to the defendant to prove all of those things I just mentioned, apportionment, to prove that they had costs associated with earning those revenues. And so you can see there was a over $2 billion judgment last year in a software case where the plaintiff's theory was, you ripped off our whole company and you just started doing the same thing we did. And the damage model that was presented to that jury was this company made $6 billion over the last, 4 years. Ladies and gentlemen, what do you think the damages should be? It was slightly more complicated than that, but that was the basic idea. And so a $2 billion verdict came out of that.
But I just want to jump in for a second, because that theory, we were developing a product or had almost finished completion of development of a product, or of a complete business in itself. Employee leaves, starts a competitive product, either gets to market sooner or gets to market shortly after. I mean, if you get caught with your hand in the cookie jar there and somebody did bring something over, you're in real trouble based on this disgorgement theory. And again, this isn't a fact pattern that comes up on occasion, that comes up sporadically. This is a fact pattern we see all the time, especially in tech, especially in startups. You have sometimes high turnover with employers, and also you have small companies that are growing rapidly as they get additional seed rounds. And you didn't have kind of the protections in place related to your trade secrets that a more sophisticated, developed company might have. So just the repeat fact pattern we see along these lines and the types of damages we're seeing with that specific theory is just so common.
Got another question in the back? Yeah, it's a good point. And that interplay gets very complicated, right? Because your damages are driven, your damages can be driven contractually. You can have an indemnification clause and you could have contractual damages. But you could argue that the damages that are available under the Defend Trade Secrets are these statutory damages, or on this slide, the enhanced damages are, completely separate from the contract. The contract, in the example that I'm imagining based on your question, is, you have two companies that have entered into a commercial agreement. They have like a limitation of liability clause in that commercial agreement, and the agreement required company B, the defendant, to keep the information secret or not use it inappropriately. And then they did. So the breach of the contract ends up being evidence of the misappropriation, but it's not, the theory is not necessarily driven it's not just a breach of contract case. You see these hand in glove all the time. Count one, breach of contract, count two, theft of trade secrets. But the argument as a plaintiff there is, this is an entirely separate claim, Judge. yes, we have a breach of contract claim, but the fact that they misused this information and we took reasonable measures to protect it, like having this contract in place in the first place, it's its own thing. So we're not bound by that limitation of liability. That's if I'm on the plaintiff side. I could give you, as you can probably tell, Justin and I are very passionate about this topic, and we could talk about this all day. Sometimes we do.
And I would just say also, in the employee mobility context, a lot of times companies don't have the types of contractual language you're thinking about with their employees, especially with startups. I mean, I can't tell you how many times I've met with a startup client or a growing client where we kind of take a look at what's under the roof, and there ain't a lot there because they're building. They were getting their seed. The biggest thing was to grow the company, to build the concept. So, in a sophisticated B2B relationship, a lot of those things are there. But a lot of times in the context of where these trade secret cases are formed or come, those concepts don't come into play. And so we moved on to another slide related to damages, which is willful and malicious damages. And so under the DTSA, if a trade secret is willfully and maliciously misappropriated, you can exemplary damages up to 2 times the actual damages. And in addition to that, an award of attorney's fees. And I want to just talk about that last piece for a second. These cases are really expensive. The attorneys spend a significant amount of time and energy on these cases. They involve computer forensics. They involve specialists. They involve experts arguing that this really isn't a trade secret and everybody knows this. And I mean, they are expensive cases, especially if they go all the way through. So that kicker, that sweetener of an award of attorney's fees can be very significant in the tunes of tens of millions of dollars for a really long, sophisticated case.
All right, then the last remedy slide, I guess, is this concept of injunctive relief. A couple of interesting things here. First of all, again, comparing this to patent litigation. After eBay in patent litigation, it became very as you probably know, it became very difficult to get an injunction against an infringer. That is not the case in trade secret cases generally. It's much easier to prove that you're going to suffer irreparable harm because of the nature of the secret information. The argument goes, the fact that our competitor has our secret information at all, whether they're using it or not, puts us at risk of further disclosure and puts us at risk that they're going to use it secretly without us ever knowing. So it's much easier to get it's not easy by any means, but it's much easier to get an injunction in a trade secret case than it is in a patent case. There are some limitations. Again, I think I mentioned this, you have this cross current of employee mobility policy in the United States. And so there are protections built into the statute and also just existing at common law for employees who want to jump from one company to another.
You guys are going to have to fly through this part.
Okay, we're ready. All right, so this is a triangle. Let's move on. No, this is the basic idea of how to protect trade secrets. And the idea here is you start at the top, and this covers everybody, and you get down to the bottom, and you hope that you never make it to the bottom, to litigation. So you can have practical measures like process controls at the top. You want all or most of your employees and your vendors to be subject to NDAs and ensure that information is being, you have policies in place that are being complied with. For certain employees where it's possible, and if it still remains possible, you might have a non-compete agreement. Then if you are, again, we're hoping now we're down to a very few people. You have someone who leaves under suspicious circumstances, you send them a reminder letter. Sometimes you ask for certifications from those people if there's a very suspicious circumstance. And then in a very rare number of cases, you actually have to end up in litigation. But having those top pieces sort of protect you from having to get to the bottom there. Oh, very good question.
Yeah. Certainly. So it's typically in the context of a cease and desist letter you're sending either to the company where your former employee went and the employee themselves. And you say something along the lines of, we're going to need, if you don't want us to sue you within 10 days, we're going to need the following things. And depending on what evidence you have of potential misappropriation, that might be, we want verifiable computer forensics that you haven't taken this stuff. That might be, we want a sworn statement under oath that you haven't taken or used this stuff, and or you're going to delete it. So depending on the circumstances, what you're demanding in that certification is going to change. If I have some smoke, I'm going to maybe ask for computer forensics paid for by them. Otherwise, it's off to the races in litigation.
This is probably the only other substantive slide that we should talk about, which is this is a list of some best practices for protecting trade secrets in general, like beyond the triangle. What am I actually going to take back to my business and talk about what we're going to do? So probably the most important thing is just forget about the lawyers, make sure the stuff doesn't actually walk out the door in the first place. So restrict access, make sure that you have, and every company has this now, but make sure that you have in your SharePoint or your OneDrive, you're ensuring that only the employees who need access to these particularly valuable secret information have it. Have non-disclosure agreements in place. I mentioned that. There's an empirical study that says as a plaintiff, you are 25 times more likely to succeed in a trade secret case, 25 times more likely if the trade secrets at issue were subject to a non-disclosure agreement versus not. probably the most important factor that courts look at, and almost to the expense of anything else. If the defendant signed something that said they were not going to misuse the information, not disclose it, you have a strong NDA in place, you're way ahead of the curve. If you don't, you're really backfilling and scrambling to try to argue why you took reasonable measures to protect the trade secret. Non-compete agreements we talked about, we will talk about some more, I'm sure. Termination policies, that idea is when people are leaving, that's your probably biggest danger point. That's when the person probably has those slides, probably has that stuff. And especially in today's day and age, you wouldn't even necessarily know. They might have it on a thumb drive. They might have it in a cloud. They might have a picture on their phone. And so making sure that your HR function is working with legal to ensure that you have a good exit interview checklist. You're making sure that people are returning their information. You would not believe how many cases we work on where after you file a complaint, like after the plaintiff has accused the defendant of misappropriation, it's only then that the plaintiff realizes, oh, they also had an old laptop. The mea culpa, we should have gotten that back earlier. So that's not a good look as a plaintiff if you let the person walk out the door with a laptop containing all of your secrets.
Well, I think we've sucked all the air out of this, so we got to move on to Mary. So I'm gonna thank you.
Please pardon the second interruption. Attorneys participating in today's webinar seeking CLE credits must fill out the webinar affidavit and include today's second course code, which is 23146. Again, the second course code is 23146. A link to the webinar affidavit can be found in the chat box. Thank you.
So hopefully we'll have some time for some more questions, and we'll all be around at the cocktail discussion after the fact. But I just wanted to bring this kind of full circle because they laid out a really great framework that everybody can take back around legal and other protections. But what we tried to do was create an insurance product. What we have done is create the world's first trade secret insurance product that actually covers the value of trade secret assets if they're Can you hear me now?
Yes,
Oh,
thank you.
okay. I don't know
Sorry.
what happened. Sorry about that. Essentially, we have overcome a lot of the problems that the insurance market generally was having around trying to find a way to protect these assets. We call this Crown Jewel Protector. It is meant to be and is necessarily a full suite of risk management services, a process that companies can deploy that is both front and back end, sort of pre-misappropriation and preventative measures, the insurance in the middle, and then post-misappropriation, where we have lawyers such as the folks from Greenberg Traurig. We have valuation partners that are experts in their field that do intellectual property and intangible asset valuations for a living. We have forensics teams on standby, all to help clients respond to a misappropriation event in a way that hopefully will help them either A, get the asset back, or B, recover meaningful damages from the misappropriating party if the assets go missing in the first place. What we have done, and this is something that is somewhat, the first two bullet points, I guess I would say, are a little bit controversial in the legal industry because we, in order to create an insurance policy, require that a company identify its trade secrets up front. And the reason that we do that is because you can't very well put a property insurance policy behind assets that you haven't identified. And you don't know what they're worth. That would be like asking an organization to cover a hotel chain when you don't know where the hotels are or how well they're protected or what the value of each building is. It's just not a thing. And so we wholeheartedly believe that organizations should be identifying and creating a documented platform. We actually use a blockchain platform. We're partnered with an organization that offers something called the Trade Secret Examiner. That is a blockchain platform that allows for the tracking of the metadata of the trade secret assets, and we apply something called the 6-factor litmus test, which we don't have time to go into today, but it's very commonly used in courts to determine whether or not something in fact passes the smell test around being a trade secret or not. Once the client has identified those trade secrets and essentially scored themselves around the 6 factors of the litmus test, which include, is it difficult to reverse engineer? Do you have secret, protections around the asset? Is it known in the field or not? How many people within the organization know about it? All the things that we talked about earlier that make something either a trade secret or not. Once we have identified and the client has told us, okay, we've got 50 projects in the R&D pipeline, but 4 of these are things that we've told our investors about, our shareholders about. These are going to make our earnings for the next 8 quarters. These are trade secrets to us. We want to protect those. Once that has been brought to our attention, then we bring in independent organization to put a value on each individual trade secret asset, which we'll come back to in just a moment. In the meantime, we ascertain their information security policies and procedures, access controls, encryption, data loss prevention, all the things that we do in the cyber world today. If companies have already done what they need to do and have the reports around their cybersecurity at the ready and we can review those, then we don't need to do anything additional, but that's going to be rare, mainly because cyber risk assessments for cyber insurance policies often are very focused on PII and not corporate information, and it's a very different look that we need to have around access controls and BYOD and all of those kinds of things. We also look at hiring, firing, training, non-disclosure agreements, all of those kinds of things to make sure that the client is using best practices. And essentially, once we have agreed that these are trade secrets and they're protected well, just like you would in the tangible world, then we can actually insure them for the fair market value. We schedule the assets on the policy wording for their fair market value that's pre-agreed at the beginning of the policy period. And if there's a misappropriation event, essentially the policy wording does 2 things, right here shown as A and B. The first thing is that if there's a suspected misappropriation, the client picks up the phone and calls one of the lawyers that we have on our approved panel and says, hey, we suspect that something has gone sideways, and here's why we think that. Then we will collectively determine whether or not it makes sense to begin a forensic investigation. If so, then we would recommend that the lawyer hire the forensics firm for you so that from that point forward, everything is privileged. And everything that's discovered during that forensic investigation is protected and preserved in a way that it can be used in litigation going forward. If we are pretty certain at the beginning or at the early stages in litigation that there has in fact been a misappropriation event, then they're filing for restraining orders and injunctions and things that Greg talked about earlier that hopefully are not too terribly difficult to get. One of the things that we think that our process is going to do for clients is dramatically reduce that 2.7 years and $4.1 million that we talked about earlier, because if the client has already pre-identified the assets that are believed that they are treating as trade secrets, and we've kind of validated and stamped that both from a hiring, training, security perspective and from a legal contractual perspective, then it makes it much easier with the push of a button to go to a judge and say, we want an ex parte seizure order. Today, a lot of cases get dismissed early for a number of different reasons. But one of the statistics I wanted to share is that 114 cases last year that settled or that closed without any damages on the back end. 114 of them were closed because the plaintiff failed to identify with specificity the trade secrets. This is becoming a much bigger fact pattern. 65 or 67 of the claims failed because the client didn't have proper security procedures. Most of the claims that are failing now around those proper security procedures are resting on non-disclosure agreements, and where people haven't had, proper non-disclosure agreements in place, and not so much on the technical security, kind of cyber security policies and procedures, because that's a heavier lift for people to get over what are proper or reasonable security measures around cyber and things like that. But we are sort of prescribing what reasonable measures are to us, or really best practices are to us, so that we can get insurance capacity behind these assets. Now we can take both the blockchain evidence that the client created on a secure platform that, again, is only the metadata. So that means that, talking about the negative know-how example, we might know that it's a WD-40 type formula, where they're at WD 36, and they've spent, they've done 36, they've made a lot of wrong turns. They've spent a lot of money developing that process. They have the proper non-competes and non-disclosures in place. They've got proper security around it. And, now when looking at the value of that asset, that negative know-how plus the future value of that asset over the life of the asset brought back to net present value, and with some discount factor, factors into the overall value that we would schedule on the policy for that asset. But since we've got everything recorded on blockchain, we're hopeful that we can mitigate and significantly reduce both the time and expense to get to the point where we're getting either the ex parte seizure, or we're moving to the damages and litigation phase beyond just the preliminary injunctions. If we are not successful for whatever reason, and there could be a whole host of reasons why we don't get the ex parte seizure, or and aren't able to sweep the system and recover the assets so that the misappropriation is cured at that point, then we actually pay the fair market value of the asset that was pre-agreed, as though it's a building that's scheduled on a property policy that blew over in a windstorm and you had wind coverage. And then the onus is upon us. We take over subrogation rights and pursue the damages on the back end, using the tools under the DTSA and everything else that's at our disposal, potentially trying to pursue and receive exemplary damages, most of which would go right back to the insured on the back end of the claim. There is a finder's success fee for the lawyers and folks that have participated in that winning litigation on the back end, just like you would expect to pay them. But it's really a win-win, and we think that it will allow a whole ecosystem to develop around these assets where there hasn't been one before, where organizations can get loans on the back end of the valuation and the insurance. They can get better deals from private equity and venture capital funds, and they can protect their boards of directors, because now their most valuable assets are not only valued but insured. And we've done a pretty deep dive on the due diligence part of it. So that's really the end of our remarks. I know we went just a little bit over time. The only other thing I wanted to mention is that I have a fairly strong opinion about what it means if the FTC ban goes through. And this is Mary Guzman's opinion, not Justin's or Greg's necessarily. I think that if a ban goes through at the federal level, what that's going to force companies to do is, frankly, what they should be doing anyway from a best practices perspective. And again, my opinion, and that is to identify the assets up front so that you can create non-disclosure agreements instead of non-competes, non-disclosure agreements that apply to only those employees who have access to that know-how that rises to the level of being a trade secret. Otherwise, if you try to take all of the non-competes that are in existence, and now you have to tell every single employee that their non-compete is null and void, and it doesn't matter anymore, and just apply a non-disclosure agreement to every single employee again, and say that everything in the system that you learn about that's confidential information is off limits, my perception is that that's going to be perceived as a de facto non-compete, which is disallowed under the FTC ban. So I think, again, if I were advising clients on this, the way I would say that is to really try to focus on identifying the assets up front and then applying the proper countermeasures to the assets that have the most value. So any other thoughts or questions around that?
I was saying I had two questions for Mary related to the trade secret insurance policy. One is, hypothetically, you write a policy for an emerging company that, has a trade secret. They've started to monetize it. You underwrite it and you agree on a fair market value. You can imagine the situation where, 1 year, 18 months, 2 years, all of a sudden they've monetized the trade secret, above and beyond what the policy that you originally wrote for them, the value that was captured there. I'm just curious how that's handled. And sort of a related question is, kind of in connection with that, or kind of the, ongoing maintenance of the policy, are you kind of continually doing some kind of underwriting to make sure the company's continuing to do what it needs to do from a trade secret protection standpoint to satisfy that, you're comfortable insuring the trade secret?
Great questions. Yes, thank you very much. So I'll answer the second question first because it's easy. And the answer is yes. We will be underwriting the client every year to see if they have improved upon the recommendations that were made to them by us during the underwriting process, or by their information security firm or whomever it is that's providing the advice on things that they can be doing different and better. So for example, if they haven't developed a robust policy around what we'll call a FADE analysis of forensic analysis of departing employees. And we really need for them to do that for a certain set of employees who have access to really technical know-how. That might be a recommendation that's made 1 year, but not mandatory yet. And just like any other insurance, it might become mandatory in year 2 or 3 for them to get the insurance. The second thing about the valuation is that we do re-up the valuation every year going into the renewal. For exactly the reason you mentioned, not to mention as well, that sometimes trade secrets will fall off the list because either they've become public information or the client, the insured, has decided to patent them. And so they were really valuable trade secrets during the R&D phase, but now they're patented, and so they're no longer a trade secret. So every year we will look at revaluing the trade secrets that the client wants to insure. And I'd just like to add that something that people say to me a lot is, well, if we value the trade secrets up front, or identify and then value, I've heard kind of rebuttals or concerns about both of those things. Can we get an ex parte seizure order if you've already established theoretically what the value of the trade secret is? Is it still irreparable harm if you have a value on the asset? I did get the opportunity to talk to a judge in California about that, and her response was, of course, there might be a change in value. The value that you're assigning to an asset at the beginning of the policy period does not contemplate things like damage to reputation, a drop in the stock price, and all the other damages arguments that you would make. So it's considered really a floor. And then the second thing is with regards to potentially leaving some assets off of the list that you're creating to identify the assets, and therefore, the defendant could argue, well, if it's not on the list, then you must not have thought it was one of your most valuable trade secrets. Trade secrets, change in value all the time, and you might have something that you think is going to be the next hot thing, but it turns out to be a completely different thing in your R&D pipeline that ends up being extremely valuable. Number one. And number two, that happens all the time in regular property insurance, where people with a big property schedule leave things off of the schedule accidentally. And it's, you can still have a limit set aside for that. So, I still think the argument is it's better to identify and schedule the assets, my personal opinion. Yes, hello.
Hey, Mary. So I'm a risk management professional, as you know, we've known each other for a while. And from an insurance perspective, I'm struggling to understand how an insurance company is quantifying the premiums. Like, we operate in the large numbers, and we get data from all sorts of places. And so is there enough available information for the actuaries to do, all of the things they need to do? Or are you relying on litigation results to properly price?
Right now, I'm
process.
relying on charm and persuasiveness. No, I'm just kidding.
You're a win on that.
I'm just kidding. No, we do. There is a lot of information in the Stout report and the Ocean Tomo report and Lex Machina. And there are a lot of organizations that track trade secret litigation trends that unfortunately are all outward going. So they're looking at cases as the plaintiff. And so if they're successful in getting exemplary damages, 30% of the time, then we can back into what the compensatory portion of that might have been, which could be reflective of what the value of the asset was theoretically, number one. But number two, we used claims from the cyber market and from the reps and warranties market, which are both similar in a lot of ways that I don't have time to go into today, to cull together actuarial reports. And we did go to actuaries to try to price this for us. But at the end of the day, like any other brand new industry vertical in insurance, the pricing is, we are pricing as though the client is going to have a limits loss, a 1 in 20-year event, basically. So the base rate is a 5% rate. I'll just go ahead and share that. It goes up or down, mostly up, depending upon the risk mitigation factors the client has in place and the industry they're in and the types of assets. So for example, defense contractors are going to be much higher targets, as would oil and gas companies, just because of the nature of the assets that they own. And that their social hacktivism targets and things like that, maybe not as high on the ESG scoring end of things as somebody who makes hair dryers or who is making green technology, which we love, by the way. But the rates will have to adjust as claims start to come in. So.
Thank you for that.
You're welcome. Thanks for the question.
Do we have a way, I'm looking at you.
Yeah.
Do we have a way of getting questions from the virtual participants? I see that.
Yes, Lindsay or somebody, wait, who are you pointing at? The people in the sky
Yes,
might be able to give us, do we have any questions from the
Yes, we
people
do
in
have
the
a
sky?
few. Here's one
And
question.
by the way, we
Oh, go ahead.
recognize that we've gone over a little bit, but
We'll
we'll
take a couple. I just don't want to be the person between drinks and food.
yeah,
For those in this room, I'm getting some looks like
yeah,
it's time for drinks and food. So we'll take a couple questions, but we won't keep it.
absolutely.
And everybody here obviously can ask us, at the cocktail reception, anything they want, and we can separately email those individuals who ask questions to make sure we address everybody.
Thank you.
Absolutely. So here's one question. Any predictions on where the FTC rule might permit exceptions, such as permitting a limited NC regarding a direct competitor to a small business in the vicinity?
You want me to
Go for it.
Yeah. I think it's not a good idea to try to make a specific prediction of where things are going to end up. I think no matter where the FTC, the actual text of the rule is, it's going to be heavily litigated. It's going to be heavily litigated for a while. So I think this is a dust settles situation. But one thing that is certain, like absolutely certain, is the protections that non-competes, that comfortable blanket that companies used to have is being taken away in specific locations. And, in my view, slowly yanked away. There's a trend against that. So what you can and should do is focus on the protection of trade secrets. So that was a way of not at all addressing your question, other than to say that I don't know, and we'll have to see.
Well done.
I thought it was pretty good. Yeah.
We have a second question. Aside from the obvious, what's the best methods to protect trade secrets when licensing API outputs to clients?
Ooh, that's a really good one. Licensing trades, we could do a whole other thing on licensing trade secrets. It is very different than licensing a patent. And just one example of why is in a patent license, the licensor and the licensee from day one, from the beginning of the negotiation, they know what you are licensing. The licensee knows what the claims are. They know what their potential arguments are to invalidate the patent even. In a trade secret license, the nature of it is the licensor has something that by its nature, the licensee doesn't actually know. They don't know the secret process or the secret, whatever it is. And so there's a whole dance that you build into a trade secret license. You don't need in a patent license, that we're going to disclose the info. There's going to be a tech, we call it a tech transfer. It's going to be a tech transfer. We're going to give you the information at the beginning. You're going to make usually a very significant payment in exchange for that. And then you have to have all of these other covenants and restrictions to ensure that the trade secret being used by the licensee doesn't just end out in the wild. Another thing you don't have to think about with a patent, you have the protection you have. Happy to, whoever asked that question, come find us, and we'll talk about it in more depth.
One thing I wanted to add just real quickly, it's kind of ironic that small, or SME client startups really need a lot of help in this space, and they have, by their nature, a lot of corporate confidential information, yet private equity and venture capital funds who are looking at them, by and large, will not sign non-disclosure agreements when you're going to them for funding. Be aware and be very wary of that. So when you're talking to a venture capital fund, do not give away your secret sauce. You can dance around it and talk about it, and you can verbally explain it to them. But if there's no NDA in place, there's no NDA in place. And a lot of the litigation around trade secret claims rests on the protection that's in place. So just food for thought for startups.
Should we call it?
I think we should call it.
Okay, let's call it. I see the anxious looks here. Thank you so much, everybody, for coming in person, and thank you for those in the sky or on the video.
By the way, all of our contact details are in the presentation. Let's see. That's me, if anybody wants to know. I also am very active on LinkedIn, as is my company. So again, really appreciate both of you and your expertise, and Greenberg Traurig for hosting us, and GIPA and the US IPA for being who they are.